Of this case against Mahbub Shah. Prosecution case. In the seminal case of Mahbub Shah versus Emperor, the Privy Council delivered a groundbreaking verdict. During the pre-constitutional between eloquently distinguished between a nation of the same intention and common intention, and defined in the Indian Penal Code of 1860. On 25 August 1943, Alada, the victim in the account, set off on a boat expedition with a group from their village to gather reeds along with their Indus River bank. As they journeyed about a mile down the river, they come across the Muhammad Hussain Shah, and who was taking a bath on his shore. This man happened to be Wali Shah's father, and he warned Alada and his friend not to collect reed from the land, and he considered his own land. None of the land, they gathered the reed and began their walk with their haul. During their return trip, they ran into the Ghulam Shah, Hussain Shah's nephew. On the Ghulam demanded they give back the reeds obtained from his uncle's territory. When they refused on an altercation, broke out, Ghulam gripped the boat and tried striking Alada with a stick, but was deflected. In a retaliation, Alada and bamboo pole and hit Ghulam Shah, promoting him to cry for help.
Good morning, sir. Defendant Wali Shah and Mahbub Shah. At the point Wali Shah and Mahbub Shah appeared on scene, both equipped with loaded firearms, firing for their lives. Alada and his friend Hamidullah attempt to escape. Unfortunately, Wali Shah fired at Hamidullah, resulting in his immediate death. Meanwhile, Mahbub Shah shot at Alada several times before firing. Charging on accused, section 34, act done by several persons in furtherance of common intention. Then a criminal act done by several persons in furtherance of common intention of all. Each of such person is liable for that act in the same manner as if it were done by alone. Section 302, punishment of murder. Whoever commit murder shall be punished with death or shall also liable to fine. Section 307, attempt to murder. Whoever does not with any act with such intention or knowledge under such circumstances that if he by that act carried that death, he would be guilty of murder.
Good morning, sir. I am Alada. Would like to permission to represent the defense of this case with my colleague Amantika and Harshita. As the prosecution asserted that there is a common intention between the Ghulam Shah, Wali Shah and Mahbub Shah, but there is no evidence of common intention where observed as per section 34 of Indian Penal Code, where a criminal act is done by a several person in furtherance of common intention of all. Each of such person is liable for the act as they had done that alone. But in this, when the Ghulam Shah was attacked, he shouted for Wali Shah and Mahbub Shah for the rescue from the Alad and their friends. In order to protect the Ghulam, the Wali Shah and Mahbub Shah were present there with the loaded guns. In case of Panduran versus State of Hyderabad, the court held that a person cannot be held vicariously accountable for action of another if the purpose was not common.
Good morning, sir. There are some defense under section 96 of IPC. This section defines the general right to private defense, stating that everyone has a right to defend themselves or other against any act that causes a reasonable fear of death or seriously bodily harm, or any act that attempt to commit theft, robbery, mischief and criminal trespass. Under section 97 of IPC, right to private defense of the body and property. Every person has a right subject to the restriction conditional in section 99 to defend his own his own body and the body of any other person against any offense affecting the human body. Second, the property, whether movable or immovable, of himself of any other person against any act which is an attempt to commit theft, robbery, mischief or criminal trespass. Under section 300, exception 4, culpable homicide is not murder if it's committed without premeditation and a sudden fight in the height of passion upon sudden quarrel and without the offenders having taken undue advantage or acted in a cruel or undue manner. Sudden provocation. I denied murder on the ground of provocation. The prosecution has a reason for to react angrily, violently or emotionally. There is intentional provocation by the prosecution. The conduct of my client may not show the common intention, but it only for the rescue of the Ghulam Qasim. There is landmark judgment, Jasdeep Singh vs. State of Punjab, Year 2022. Here common intention does not attract Section 34 without an action of furtherance. Good morning, sir. The case of State and versus Babulal and Rebuttal. In that case, it is us that whatever conclusion we may come to so far and conviction under Section 302 IPC is concerned. The accused under Section 302 of the IBC, the state wants to convict the accused under Section 302 of IPC. Accused are guilty under that section. That judgment is really one of the conviction under 302 of IPC effect and ground on our legal effect, and all that state wants it is to uphold that judgment on conviction on the facts and the manners in which charges have been framed. In this case, a conviction under Section 302. The reason for the attack was collecting deeds which compelled and caused Mahbub Shah and their companion to attack Hamidullah and Al-Adad. That result is in his death. After this matter, only Mahbub Shah was caught and arrested. His other companion has been not found ever at this point. Manslaughter refers to a criminal intent, but there was not any criminal intention to harm anyone or especially causing death. Every crime has 4 stages, which is intention, preparation, attempt and result. In this cause, there was not an initial intention to commit crime, and that things done in the post-action of the prosecution. Here are some related cases. In Dasrat Singh and another versus State of UP, the learned session judge has held that the act of appellants in causing death of Nagraj Singh fell under Section 304 of IPC, as there was no intention on their part of commit. The appellant has not intention to commit murder of the deceased or to the causing injury, as would likely to cause death in the ordinary course of nature. By judges, while dealing with the appeals against Edward, no doubt the High Court has full power to review the evidence. The murder attack that resulted in death is intentional and well-planned murder by Mahbub Shah and companions with the intention to kill, according to Union Penal Code Section 302 and 307. Whoever with this intention caused in various different circumstances has done something which is the cause to death is guilty to murder. So is Mahbub Shah and his companion also has murdered Al-Adad and Hamidullah. And here it is relating it to Section 302 of the IPC, Williams-Ranley versus the State of MP. The court below were convicting the appellant of the murder under Section 302 of the IPC, assuming that the actual prejudice is necessary, then is the only charge against the appellant being one under 302. Read with the Section 304 that having success due to the convicted to the co-accused and the appellant having successfully shown that the common intention and completed by Section 334 of the IPC, prejudice is to bound occur due to his conviction under Section 302 of the IPC.
As the prosecution is stated that Mahbub and Walisha attacked to the Alad, but the Alad triggered the Ghulam while attacking him with the bamboo, and Ghulam was shouted for help, and thereby the Mahbub Shah and Walisha come with the loaded gun. That there is no manslaughter and no prearrangement of crime.
Sir, but the Mahbub Shah fired a single barrel gun and Walisha fired a double barrel gun. Here it shows on to it shows on the bench and they were prepared for the commit the murder. That's the only reason, and there's a common intention implies a pre-planned scheme and requires evidence that the criminal act proceeded according to this.
In fact, Mahbub Shah and Wali Shah stood in different parties. It is difficult to believe that they have common intention of killing one. There was no evidence and circumstances from which it might be conferred that they involved in common intention.
After this matter, police was also present after this incident and only Mahbub Shah was arrested by the police.
As per Section 103 of Indian Evidence Act, it states the burden of proving a particular fact is lies on the person who said them. As the prosecution has stated that there is a common intention but does not present any evidence against the Mahbub Shah, and it is only a circumstances and heat of passion that Mahbub Shah came with the loaded guns.
Sir, there is a case which is related with the Mahbub Shah versus Emperor, wherein the Kumar Ghosh versus the King Emperor. In this case, two people demanded money from a postman and he was counting the money, and when they sued for a handgun at postmaster, he died on the spot. This case shows on this is a pre-planned murder, and this is also a section 34 and 32.
Under Section 34, there are some essential elements which are to be conducted, but there is no common intention between the Mahbub Shah and Wali Shah. There are some related cases in Harishan Kisan versus Sukhbir Singh. Intention of the five accused was obviously to commit murder of Joginder, and their acquittal under Section 307 of IPC was preserved. Disposing of the appeal, the intention of accused was obviously to commit murder of Joginder. Their acquittal under Section 307 of IPC is characterized as perverse. At any rate, it seems to us that they had no intention to commit murder. But according to Section 34 of the IPC, it must be demonstrated that one accused person committed the criminal act in pursuit of the mutual intent. If proven, any of them can be held liable for the act individually. Thus, the common intention implies a pre-planned scheme and require evidence that the criminal act proceed according to this plan. In this related case, Maheshwari Yadav versus State of Bihar, the Supreme Court gave this judgment. Section 34, it is not necessary to prove their prior conspiracy or premeditation. It is possible from the common intention.
Sir, the Indian prosecution story states that Gulams were shouted for the rescue for two Mahbub Shah and Wali Shah, but there is no prior meeting of mind is shown, and also they are not present any evidence regarding such things. For this, we have a case, Krishna Gopal Patel of the state of Maharashtra. The four accused were recruited from other four as he does not share the pre-arrangement of mind. The Section 103 of Indian Evidence Act, as I mentioned earlier, the burden of proving is on prosecution, but he does not show any evidence, so my client is not guilty.
Sir, Mahbub Shah and Wali Shah had already put a gun. So Wali Shah is a single-barrel gun and Mahbub Shah is a double-barrel gun. Why they put it on? There is no pre-planned and there is no conspiracy, criminal conspiracy. Why they put it?
I am saying that there is no pre-arrangement of mind or there is no common intention.
Why they put on the guns?
Because they are trying to help
What
their
kind
friend.
of things they try to do?
They tried to rescue their friend.
And it is circumstances which
So there is a pre-plan, na?
how it is pre-planned. If you are shouting
There is
to
a
me,
mutual intention to prove it.
there is no intention. That what I am saying. There is only a circumstances where a person attacked to his friend and he shouted for help. His two other friends come with what they had at that time.
Sir, according to Indian Penal Code IPC 302 and 307, whoever with this intention was in various different circumstances has done something which is the cause that is leading to murder.
And sir, dispute over deeds were not the reason for this matter. To reach murder conclusion, Mahbub Shah have taken a better way by using the legal way that could resolve the issue in relatively peacefully way. So sir, it gives justice to deed Al-Hadat and Hamidullah should delivered as harsh possible punishment to you. Here are landmark judgment. Subhash Rai versus State of 16. Apex court that this fact appear to prove that they had no intention to commit murder, neither they have any motive. Hence, the acquitted was not disturbed. It would be per person using the firearms. The Honorable Apex Court found no intention or knowledge to commit either murder or attempt to murder and acquitted the accused person. In 2000, Supreme Court circumstances mentioned in that the intention or knowledge of the accused must be such as necessity to constitute murder. Without this ingredient being established, these can be no offence of murder. But at that point, Wali Shah and Mahbub Shah appeared on the scene, both equipped with the loaded firearms, and fearing for their lives, Al-Hadat and his friend Hamidullah attempted to escape the cause of death.
As the prosecution advocate mentioned, that there is a legal way which Mahbub Shah and Wali Shah should use. But Ghulam was firstly when they came, he said that do not take the risks. After all that saying, he and his friends continuously doing the thing that he is not, that he is denied. So at that time he used what way either that circumstances needed, and when Allah attacked him with bamboo, so the only option is just shouted for help, and when he shouted for help, his friends come with what they could done.
If there is no intention to murder, why there is continuously fighting?
There the circumstances are there. His friend shouted for help. The other two friends, whatever they had at that time to rescue their friend, they go with them. So there's no, if they had sticks, they are go with them. So there is no intention. Where is the intention is shown? I don't understand.
They tried to defend their friend.
The only thing that you also said in the story, that Ghulam shouted for them. How can you counter yourself?
The reason for the attack was collecting deed which complied and accused Mahbub Shah, and their companion to attack Hamidullah and Al-Hadat that result in his death. After this matter, only Mahbub Shah was caught and arrested. His other companion has been not found even at that point.
I would like to take a defense of section 300, exception 4. Culpable homicide is not murder if it is committed without premeditation in a sudden fight, in heat of passion, upon a sudden quarrel, and without the offence having take undue advantage and acted in a cruel and unusual manner.
So it gives justice to deed Al-Hadat and Hamidullah. We should deliver as harsh possible punishment to them.
The sole point that prosecution has stated from beginning to end of the case is there is a common intention and intended to kill, but they did not show any evidence. There's only a thing that they only had a single intention but not a common intention, and according to Indian Penal Code 1860, same intention is not a crime but a common intention. The allegation of section 302 read with 34 of IPC is not conclusively proved. Lastly, I would like your attention that they had no proof any evidence regarding section 302 34 and section 307. So I want my client is falsely implicated with this section. I want a fair trial for my client. Thank you.
After this matter, police was also present after this incident, and only Mahbub Shah was arrested by the police. How can you say that there is no evidence? Mahbub Shah was arrested by the police
In a prior meeting,
with their gun.
as I told you,
Yes, but we are stating now section 300 clause 4 is an exception. That means that not a murder but a culpable homicide.